The following news flash is brought to you by the Lone Star Lowdown. Markets for Monday, the 16th of May, 2016, are currently trading with gold at $1,272.20 an ounce, silver $17.12 an ounce, Texas crude $46.21 a barrel, and Bitcoin is currently sitting at about 458 U.S. currency. Today in history, the year 1918. The Sedition Act is passed by U.S. Congress, making criticism of the government an imprisonable offense. An expansion of the Espionage Act of 1917, it banned speech and the expression of opinion that cast the government or the war effort in a negative light, of course excused by the perceived interference with the sale of government bonds. The end of free speech in the U.S. during wartime. Today in history. In recent news, a Texas openly gay church pastor, Jordan Brown, wrote in a statement today that Whole Foods, the company, did nothing wrong. This after he back in April had requested a cake from the all-natural organic grocery store with the phrase "Love wins" on it, but then claimed that he received a cake with an added homophobic slur. Brown said in the statement today, quote, "I want to apologize to Whole Foods and its team members for questioning the company's commitment to its values, and especially the baker associate who I understand was put in a terrible position because of my actions. I apologize to the LGBT community for diverting attention from real issues. I also want to apologize to my partner, my family, my church family, and my attorney." Whole Foods filed a countersuit against Brown and hasn't stated whether it would drop the action now that Brown has dropped his frivolous lawsuit. The University of Miami has detected a radioactive isotope produced by nuclear reactors in Biscayne Bay, spiking at 200 times higher than normal level at the Turkey Point nuclear power plant located just south of Miami, confirming suspicion that Turkey Point's aging canals are leaking into the nearby national park. South Miami Mayor Philip Stoddard, who is also a biological science professor at the Florida International University, told the Miami New Times, quote, "You would have to work hard to find a worse place to put a nuclear plant right between two national parks and subject to hurricanes and storm surge." Laura Reynolds, an environmental consultant who worked with the Tropical Audubon Society and the Southern Alliance for Clean Energy, which intends to file a lawsuit, stated that, quote, "We know now exactly where the pollution is coming from, and we have a tracer that shows it is in the national park. We are worried about the marine life there and the future of the Biscayne Bay." This leak comes only several months after New York Governor Andrew Cuomo acknowledged that the state's Indian Point nuclear facility was leaking tritium into the local groundwater. The Indian Point nuclear power plant is located on the Hudson River, approximately 25 miles north of New York City, and serves the electrical needs of an estimated 2 million people. This is Rick Brody with your lowdown for May 16th, 2016.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack, and we have just ended with Mauricio. Randy, you want to take over?
Okay. Mauricio, is that right?
Yes, sir.
Okay. Where were we? You were working over as a judge. Now you got a bunch of bailiffs around you. What did they do?
I was able to... Now, keep in mind, all of this is occurring in a small town called Bishop. Roughly 200 people. Their main police department maybe has 2 police units. So I had the 3 constables chest butting me, screaming in my face, asking what did I do to the judge, so on and so forth. And I got in the plainclothes officer's face, and I asked him if I was arrested, if I was under arrest for anything. And he kind of pushed back at me and said, "Well, not yet." I go, "Well, then I'm free to go." And I turned around, and I walked away to the only gas station in town, and that's about a block down the street. And that time, a local PD unit pulls up, and there's now 2 city police officers and 3 constables out there. I grab a coffee, drink it, just calm my nerves down, turn on my cell phone, and then turn on my recording device and head back. Well, the 2 local PD take off before I even get there when they see me walking back. The 3 constables remain standing right in front of the small courthouse, or the main entrance of the courthouse. And now I do have all of this recorded. So, and I walked up, and the plainclothes constable began to speak. "Well, I understand what you're doing now. You're making this big old scene that way that you're not found guilty, and it won't show that you don't have a license, which would prove that you're driving illegally, and automatically you would go to arrest and go to jail." And he's like, I see what you're doing. I see the big story." Well, then I politely responded, "Oh, see, sir. And how exactly do you know that is my plan?" And he began to start a little bit, and we went back and forth, and finally I told him that, I notified Larry that, I go, and I'm referring to him as Larry because I don't recognize him as a judge or a magistrate because he never showed jurisdiction. I went in there telling him I'm at arm's length of the court, challenging subject matter jurisdiction, and Plus there was no facts and evidence that they even could continue on. And the constable tells me, look, I have no idea what you're talking about. Because I'm just here to do my job. I go, and that is to harass me, right? I go, because the judge did tell you that if I get my...
Wait a minute. Hold on. That is not harassment. That is witness tampering.
Oh, really?
That's a felony.
Well,
okay.
This is why I'm calling.
Was this your first? let me back up just a little bit. You got a ticket, and this was your first appearance at the court?
Yes, sir. It was the appeals.
Wait a minute.
The arraignment where you go and you plead guilty or not guilty.
No. Hold on. You're in Texas.
Yes, sir.
An arraignment is a hearing for the purpose of determining your identity and taking a plea. An arraignment can only be held in a felony case after indictment or in a case punishable by imprisonment. So this couldn't have been an arraignment. This had to be an examining trial.
Okay.
If you look at your ticket, it tells you to appear before a judge. But if you look at the code under 543.006 says that you agree to appear before a magistrate of the county, not a judge.
I understand that.
So this is a hearing for the purpose of an examining trial.
So at the time when we were speaking, he would have been wearing his magistrate hat.
Yeah, that's what he should have been wearing. You need to file witness tampering against the judge.
Okay. Well, it gets a lot juicier, trust me. We've so far climaxed on Thursday, and that's why I'm calling you to kind of get advice for what the next steps of the fight is.
Next step is you make up a criminal complaint against the judge, a motion to recuse the judge, a criminal complaint against each of the constables.
Well, now, Thursday I just went to a trial and was found guilty.
Of course you were found guilty. I mean, that's the whole deal.
There's still more to the story.
Okay, go ahead.
Put in Eddie. Okay, let me go ahead real quick. I had notified him all that good stuff that, which I thought was harassment, because there were 3 men with guns preventing me from getting in my private property, and he went off about how the guns were part of the uniform, and that's when I responded. Look, I take those things very seriously. They can do real serious damage, and they're within a couple of inches of grass from these gentlemen. And if I do anything that they find threatening or wrong, they can pull it out and justifiably shoot me. And he started laughing. He said, "Oh, you're just over-exaggerating." That's when he started speaking in an exaggerated term directly into my camera where I was recording him. So then I told him, you know what, let me go inside and let me get the paperwork I need to get. I went into the clerk. Clerk notified me that all the information would be mailed to me. Okay, so I go back out, and there's only 1 constable left. So I sit down, and we have somewhat of a conversation. And I asked him, I said, now I'm curious. I go, you're a young guy doing your job. You got bills to pay. Have you ever read what your job dictates? I go, could it be that your job is to issue warrants and subpoenas and to be a chase vehicle for DPS? And nowhere does it actually say anything about enforcing the transportation code? He goes, well, it might be policy. I go, well, do you know who wrote the policy? I'm pretty sure the local Texas Ranger would be interested in a criminal complaint stating that because he doesn't supersede law. And that's when he really got quiet. And he told me, look, I need to go on a lunch break. I'm trusting that you're going to wait for your ride to come pick you up. He went, got in his car, stayed looking at me for a while, then took off. I got up, got in my car. The judge was staring at me through the window. I took off. I received a letter to go in for a pretrial hearing. So I went in there, and everybody else who was there, I don't know exactly what they were there for, but they were able to go into the courtroom, speak with whomever first, and then come out. I was the last one called in, and when I was called in...
Whoa, hold on. Hold on. You were not allowed in the courtroom?
No. No, nobody was. There was one person at a time.
Okay, go ahead.
Now, when I went in, I was the only one that was called in by a constable. And when I went in, I was escorted by the constable. Then he stood behind the 2 attorneys, and there was another constable on the other side of the courtroom, basically behind me. And that's when I argued that, the 2 citations that they're trying to hit from back in 2012, they're past statute of limitations, they need to be thrown out. And she said, okay. So she signs them off. She gets the other two, and she goes, as for these two, what are we going to do? And I told her, look, I'm telling you what I told Larry. I go, again, I'm here at special appearance, arm's length of the court. I go, challenging subject matter jurisdiction. And she's like, okay. She goes, so you're going to refuse to plead? I go, no, ma'am. Like I told Larry, I go, I'm not refusing to plead, it's just I do not understand the nature of the charges. So she went in and signed out the paperwork because I even argued the fact that I was not in commerce, that I asked the officer if he never asked for a bill of lading, passenger manifest, commercial logbook. He never asked for anything. I go, so you don't have any evidence to continue forward? And she said, yes, if you were driving, you need a driver's license, we're going to continue. You're out of your mind if you think we're just going to dismiss it. So then she takes off to the back, and I go and I sign the paper.
Wait, hold on. She. Who was this she person?
They were both the attorneys.
Where was the judge?
The original judge, he was not in the room.
So the judge summoned you, or issued a summons ordering you to appear so you could meet with the prosecutor.
Yes, sir.
That's abusive process. He has no power to do that. If a prosecutor wants to talk to me, the prosecutor can call me and set an appointment. Mm-hmm. But if the judge orders you to appear before a prosecutor, that's abusive process. That's a procedural due process violation, and that's a crime in the state of Texas. 39.03 Penal Code, official oppression. Okay, go ahead.
All right. So I walk out, get in my automobile, take off home. I go in 10 days before the trial, and I turn in Eddie's constitutional motion for both the case numbers. It's one citation. It was two violations, two case numbers, so I turned in two motions, one for each. The written challenge for the subject matter jurisdiction, the constitutional motion, boom, put them both in. Receive a letter, probably 4 days before trial, that all motions will be heard on the day of trial. Go in that morning. I objected to having the motions heard on the day of trial, stating that it showed that the court never intended to take my motion seriously, that they intended to find me guilty all along, and I forgot exactly what else I worded. And she basically, now, this is what I forgot to mention. When I go in the day of the trial, the day of the pre-motions hearing, the day of the trial also, it is a different judge. All right? The original Judge Larry, I guess, recuses himself. So another judge comes in. She comes in saying that sometimes they switch places, and that this time she would be conducting court, although Larry's sitting in the back seat of the courtroom, who is the other judge. And it's only another constable, and the door is closed to the courtroom. Now, I make all of the arguments there. She gracefully denies my motion. She tells me that she's so sorry that I feel that way, and that she will guarantee me that I get good due process under the law. But she denied it. So then I make the arguments about the enactment of the SB 971, the way that they used the emergency clause, and they did it incorrectly, and so on and so forth. I did the whole argument as best as could. So then her response is, well, that is a legislative decision-making, and I am a member of the judicial branch, so therefore I'm unable to decide on your motion. So because of that, I'm going to have to deny it. Now, we'll take a 5-minute break, and then we'll begin jury selection. So Larry gets up from the back, walks past the aisle, and goes out the same door that the other judge walks out, or, the judge's entrance. I'm running through the witness information as fast as I can to see who I can disqualify.
Okay, wait, hold on. This is going to take the whole show the way we're going. We need to go more quickly.
Okay, I'm sorry. I'll finish it up right now, or when we come back, if that's okay.
Okay, Randy Kelton, Vet Pack, we'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get me.
We are Rule of Law Radio with Randy Kelton, Vet Pat, and we are listening to Mauricio out of Texas.
Okay, Mauricio, we are at the point of picking the jury.
Yes, sir. It's done real quick. I'll go ahead and just fast forward everything and just make the quick points. The old judge, Larry, is still sitting in the back. There are two constables in there. I get the city constable up there. He admits that he never asked any of the crucial information needed. Basically got everything set up for appeals, put in my video as evidence as, that the officer had his hand on his gun, showed it to the jury. When they were showing their evidence, I guess conveniently for them, the first part of the citation, or the first part of the traffic stop was not recorded. Apparently the recorder in the truck wasn't working. And he had just remembered to turn on the body camera, and that's why they only had the second part. Long story short, I appealed every time they would use a commercial term, to the point where she finally started saying traveler and automobile, but they were all overruled. Even the prosecutor got up and said that I'm not arguing transportation. So then that's when I asked for a divert verdict on my behalf, showing that, if the state had no intentions of implementing the Transportation Act, how could they implement or the Transportation Code, how could they implement an act under the code? And that they had just admitted public or open records that they had no intentions of utilizing that code, the Transportation Code. That got objected as well. Found guilty when they went to verdict deliberation, the jury deliberation. The jury was allowed to stay in the courtroom. Everybody else had to leave. And that's when Larry, the other judge, gets up from the back of the courtroom, goes out the back entrance where both the prosecutors get up and leave with both of the judges. So come back, found guilty. That was it. I went. I told them that I would be putting appeals. The judge put bonds on the cases. Went to the front of the courtroom, waited for the constable to quit smoking a cigarette, went inside, quit eyeballing me, got in my car, left, and now I'm calling you.
Okay, you have a number of criminal complaints you should be filing.
Okay.
Not the least of which, first-degree felony aggravated assault against the judge for sticking the bailiffs on you, or their constables on you.
Okay.
And the office, this is what I filed against the local district judge where I'm at because he committed first-degree felony aggravated assault against me by assaulting me with the bailiff. He assaulted me with a deadly weapon. The bailiff was the deadly weapon who was prominently displaying a deadly weapon at the time. So when you went in for an examining trial, because the judge didn't like the fact that you asserted your rights, he had you accosted by these bailiffs, and they all had pistols.
Okay.
I would file first-degree felony aggravated assault against each one of them. What county is this in?
It's in Nueces County.
Okay.
Their main court is out of Corpus Christi, but this was out of a smaller court, KP Court in Bishop, Texas.
Good. Take your criminal complaints to the grand jury. Have you heard my dissertation on how to address grand juries?
No, sir, not yet.
Okay. The way I read the code, 20.09 says, under duties of grand jurors, it shall be the duty of the grand jury to investigate into all crimes subject to indictment that come to their knowledge by way of any member of the grand jury, by way of the prosecuting attorney, or any credible person. Have you ever been convicted of a felony?
No, sir.
Are you over the age of 18?
Yes, sir.
You are a credible person by statutory definition. So, you find out when the grand jury meets, and if it's Corpus, you've probably got a grand jury meeting every day. You go down there and go down to the courthouse and find out, see if you can get them to tell you where the grand jury room is, what room they meet in, and then go to the district attorney and ask for a itinerary for the grand jury. And they're going to ask you why, and you can tell them that you will be coming down to file criminal accusations under 20.09 Code of Criminal Procedure. If they interfere with you in any way, then they tell you, well, you have to file it with the police department, and the police has to file it with us. You can't file it with the grand jury directly. Then you make up a criminal complaint against whoever tells you that, and that's what you bring to the grand jury first. So your reason to go to the grand jury directly is you're accusing the district attorney, and it'll be the district attorney's office that'll do this, of shielding these public officials from prosecution. we're going to run out of time. We're running a little late today, and we've got a whole bunch of callers, so I'm not going to go through all of this procedure today, but we call this kind of running the routine. Let me go through it quickly. First thing you do is you take a verified criminal affidavit for each complaint you're going to file, and you take it to the district attorney. Well, the district attorney will send out an investigator, and he'll look at it, and he'll tell you have to go to file it with the police department. Get the name of the investigators. Keep your recorder with you. Get a second recorder beside your phone. And if they ask you if you're recording them, say, absolutely. And take out your phone. And if they ask you to turn it off, turn it off. Don't turn off the second one. Okay. When they tell you you have to give it somewhere else, as far as you are concerned, you are talking to the district attorney in the capacity of respondeat superior. So the district attorney is telling you this, not these guys. They're just mouthpieces for the DA. So when they tell you that, then you say, oh, okay, and you go away and you make up a criminal complaint against the district attorney. And depending on how you want to do this, I prefer to take that complaint to a magistrate, preferably the highest magistrate in the district, a district judge. And the reason being is I want the district judge to refuse to take my complaint and hold an examining trial based on my complaint. But when you do that, and when he refuses, he's going to let the district attorney know that you were there trying to get complaints filed against him. And he's going to ask, what the heck is going on here? And it's going to take him a while to figure it out that his investigators sent you packing when you brought criminal complaints against public officials. Are you familiar with Article 2.03 Code of Criminal Procedure?
Not yet, but I will be.
Okay, what it says is, I'm paraphrasing here, it's kind of long. When a prosecuting attorney is made known that a public official has violated a law relating to his office, he must reduce the complaint to an information submitted to the grand jury. No discretion of any kind concerning public officials. Special statute exempted out of the normal criminal process. Okay. So when he exercises discretion and refuses to take the complaint and sends you somewhere else, then you charge him with official oppression. You take that to a district judge. The district judge is going to read that. He is not going to be happy because, he's likely to tell you, well, this is our policy. And you say, well, I'm not really concerned about your policy. I'm concerned about the law. And he's not following it. Now you need to hold an examining trial. And he's going to refuse. I've never had one do it yet. Then you come back to the district attorney with criminal complaints against the district judge. Once you have criminal complaints against the district judge, if anybody says anything to you that you can in any way interpret as a threat, like giving you fair warning of all the trouble you can get into, or the prosecutor telling you that he'll charge you with jury tampering if you try to give that to the grand jury, then you make up complaints against them. If it's a bailiff or somebody with a pistol, you make up I'm sorry, I said against them. You make up a complaint against the district judge.
Randy, we're going to have to take a break. This is Rule of Law Radio. Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back.
The Chicago Blackhawks stunned the hockey world by coming out of nowhere to win the Western Conference Finals. Their secret weapon was a readily available health supplement. I'm Dr. Catherine Albrecht, and I'll be right back to tell you how they did it.
Google is watching you, recording everything you've ever searched for and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage.com doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
What shot the Blackhawks to victory? Vitamin D. When team members took a daily supplement, they caught fewer colds, recovered faster from injuries, and their game took off. And it's not just athletes who can benefit. Your body makes vitamin D when sunlight hits your skin, but adults who work indoors and kids who watch a lot of TV probably don't get enough, putting them at risk for illness, bone problems, and even heart disease. Be sure you and your kids get 10 to 15 minutes of sun exposure several times a week, or ask your doctor about a daily natural vitamin D supplement. You can learn more about this amazing vitamin at vitamindcouncil.org. This is Dr. Catherine Albrecht. More news and information at catherinealbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Welcome back to Rule of Law Radio with Randy Kelton, Vet Pack. Randy, go ahead.
Okay. I'm used to women ordering me around, so this is great. It makes me feel at home. Okay. Mauricio?
Yes, sir.
Okay.
And having a big, strong woman order you around isn't too bad, Randy.
She's 5'2" and could pick me up in her hands and break my back.
At least I was right about the strong.
Okay.
Sorry, I had to.
Okay, you got the idea. They wanted to jerk you around using their authority. Now you use yours. Once you've been to the magistrate and you file against him, then if anybody says or does anything that you can in any way take as threatening or intimidating, you accuse the judge of doing it. I'm working on a tank beside my house. I own a big lot next to City Hall. And I had a bunch of equipment out there, and I'm working on this tank, doing some plastic welding with a little torch. And we had a drought at the time, and a fire ban, this new cop that didn't know me, I hear, sir, and I turn around, there's this new cop standing there, and he said, you can't have that open flame. I said, sure I can. Look, nothing to it. No, you don't understand. We have a fire ban on. I said, you see this equipment? I can outrun the fire department with it. It's all high-pressure spray equipment. I understand, but you can't have that open flame. Wait a minute, you're joking, right? Oh, no, sir, I'm not joking. Wait a minute. That District Judge John Fostel sent you down here to harass me, didn't he? Just because I filed one crummy little complaint against him with the Texas Attorney General. He sent you down here, didn't he? The cop stepped back, held up both hands with his palms out. One moment, sir. Takes out his cell phone, makes a call. In about 30 seconds, Tom, the chief of police, stepped out of City Hall. He looked across at me and said, Randy, what are you doing to my new officer? Oh, Tom, I was just jerking his chain. And the cop said, oh, God, I saw my whole career pass before my eyes. They are terrified of the judges. Everybody's terrified of these judges. You don't have to be terrified of the judge because he works for you. And if he forgets it, you kick him in his professional behind. So you want to get to the highest judge you can with this complaint. He's going to be real nice and professional and tell you how you got to take it to the police department. And then you file against him and bushwhack him. And he is really going to be an unhappy camper. But he's not going to say anything to you. That's witness tampering or retaliation, 3605, 3606, respectively. Both of them felonies. So he's going to tell you the only place he can go is everybody else. See, everything's political. You never win your case because you have the law and the facts on your side. You win your case if you have the politics on your side, and this is how we create some serious politics. You start running the routine on them, and then you file the appeal. Now you got the county judge in a position to where he knows you're gunning for him. So what's your purpose, Mauricio, at the end of the day?
Well, like you say, when a child misbehaves, you're not punishing them because you don't love them. You're punishing them because you want them to correct their behavior.
Yeah, well, I use the analogy of my grandkids. I love them dearly. But if one of them runs out in the road, I'm fixing to tan his hide.
Yes, sir.
But at the end of the day, what is your purpose in taking on this issue?
Oh, well, financially dictates my intention. So ultimately, to have the citations go away, and I'd have to.
Okay, that was what I wanted to find out. So you're not here to change the world. It'll be nice if it changes some as a result of what you do, but primarily you want this case to go away. Okay, what you need is politics. It's all about the money. So what's going to cost them more money? Them dropping your case, or trying to continue to prosecute you with you filing criminal charges against everybody that moves? And have you bar grieved the prosecutor yet?
Not yet. Now, would I do it to both of them?
Absolutely. And judicial conduct complaint, both judges.
Now, I found the forms, was able to print those out. Would you recommend anywhere that has a good sample style for the criminal complaints and everything else? Or
yes, send me an email. I just happen to have a bunch of them.
God bless you. God bless you. And one more question, I will actually leave you alone because I've taken way too much of your time. I was told by the clerk that I only had 10 days to appeal or to put in my paperwork.
You have 10 days to give notice of intent to appeal.
Okay.
And you have to put up a bond for each of the fines.
Right. They were significantly higher than what the actual cost of the citation was also, but
double.
Yeah.
Yeah, it's statutorily double. That needs to be fixed, but that's how it is.
It's interesting, but it is what it is there. Would I be able to get a good sample of how to put in an appeal also with the email?
How to put in what?
Put in the notice for the appeals.
Oh, you just make up a motion form and put, I hereby give notice to the court of my intent to appeal.
Oh,
that's
simple.
All that is. And actually, they have a form that's notice of appeal, and it also includes affidavit of inability to pay. So just ask them for the form; they'll give you one, and you just write in there. This, I think, is just filled in the blanks.
Perfect. Well, I'll be going to Eddie's class on Sunday also, and I'll continue corresponding with you on email.
Wonderful. Okay. Thank you, Mauricio. Okay, now we're going to Marshall in Washington. We're going to get an update on the gun range incident. Hello, Mr. Marshall.
Good evening, Randy. How's it going?
It's going wonderful. I now have a co-host to order me around. It makes me feel at home.
Oh, that's good. That's good.
I can bark commands temporarily if somebody needs a break.
Oh, they're different coming from a guy. I'm married. I'm used to being ordered around by
Sure. So anyhow, I don't know if you want just the update part, or do you want me to give some background for the whole situation?
Give a real quick background so everybody will understand what you're talking about.
Okay. So this is the Kitsap Rifle and Revolver Club. We've been in litigation with the county for actually a number of years now, and are currently at trial court level in 2 cases before 2 judges in 2 different counties. They actually sued us in a different adjacent county, and that's been to the appeals court and come back down. And in the second court, relative to a very recent gun range ordinance they put in place. And they're applying to us, despite the fact that we have an appeals court ruling that says that we have grandfathered rights that are protected. They claim we're not allowed to operate a gun range, even with our grandfathered status protected by an appeals court, without their approval. So the more recent developments in that are that after being shut down for nearly a calendar year, the gun club did apply for the gun range permit, but we did so with lots of legal reservations and whatnot. And we submitted an application that exceeded 100 pages in length and was 4.4 and 5 times as large as the other gun range, which is the favored child in the county that does as they're told, submitted. We submitted something with a lot more detail to it.
Marshall, we're going to have to go to break. I'm just going to hold on for a second. This is Rule of Law Radio. You've got Randy Kelton, Vet Pack. Please call us at 512-646-1984. We'll be right back. Easy.
For. When I'm hungry, I like to know just what I'm fishing for.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. We are listening to Marshall right now. Marshall, you want to continue?
Sure. So we had applied for the permit and had asked the judge to lift the injunction that had closed the range completely to firearms discharge. And we allowed archery and some things, but closed it to firearms discharge. And we went back to court, and the county objected to having the injunction lifted because our application was incomplete, despite the intricate detail and great effort we put into it. And after some discussion in court, the judge seemed to get very, very concerned, for lack of a better description, and said, well, words to the effect, we had to have an evidentiary hearing on this. Looks pretty good to me, but you want to have a hearing, we'll have a hearing. So anyhow, it ended up that the judge, later hearing, opened the gun range and gave us what we had been seeking as some stipulations from the county, got it as a court order from the judge. He listed a number of things protecting certain rights to our legal process and whatnot that we were looking for. So the short and long of it is we are open under the second case, but the first case still has us under restrictions. So that's the size of that situation. So we have 30 caliber restrictions and a number of others. I got the list here in front of me. No commercial for-profit uses, no military training uses, no use of high explosive devices, including explosive targets like Tenorite, for example. No use of high caliber weaponry greater than 30 caliber. And possibly the most egregious, a ban on practical shooting uses, including organized competitions and practice sessions. And this is a shooting range that has been open for just short of 90 years. And this, the injunction I just read from, was a nuisance injunction. Well, if you move in next door to a gun range, you might expect to hear gunfire, some people might say. So those are basically the two cases we have in place. The second case we are reopened from at this point. We got dismissed, the county's side of that civil lawsuit, but the judge refused to dismiss our side of the lawsuit, where we had a counterclaims for damages and a couple of requests, which was basically a judicial finding that we could operate, albeit possibly to some limited extent, without a permit under our grandfathered rights. And in the alternative, because of some technical violations, throw out the gun range ordinance in its entirety. It turns out that the state has a preemption in this area, but it has an exception, and it lists what they have to do to utilize the exception. And possibly a couple, but certainly one of the steps that they're required to do, they left out completely. And while the courts, under ideas of public safety, will allow almost any excuse to legislate at the local level, they don't let you do it with no basis at all. So they have to actually claim that somebody's been injured or some property's been damaged, which they do not claim and did not claim before they passed the ordinance and didn't document that sort of thing. So that's where we're at. And the most interesting part is that we are past 4 weeks after the end of the case, and we don't have a ruling from the judge. Not only I'm not saying we don't have a written ruling, we don't have any ruling. So 4 weeks out, so our lawyers are kind of considering that he might actually be throwing out the ordinance altogether, the ordinance under which we were closed for a calendar year. So they're considering whether we should, there's been some recent decisions in the Ninth Circuit that are gun-related that are kind of pointing to this issue. And they're wondering if we shouldn't submit some extra references to these other cases to the judge. They said we can't make any more arguments, but we can certainly submit additional case law that happened between the hearing and now. So what does Randy think? Should we leave well enough alone, or should we submit some more legal references?
I would say it sounds like the judge did not have a predetermined ruling. He's taking some time. So it's a good chance he has his clerks going over the case law. So I would definitely want to, if there's new current relative case law, I would definitely want to get that in his hands. Well, and I can't see that as anything that would annoy the judge or would seem in any way improper or out of place.
Yeah, the new ruling is basically derivative of the Heller decision. Basically says that when it comes to areas of nuisance, which is basically, well, it's not the other case, but this is related to that. The standard to be used by the court is strict scrutiny, which, as I understand it, is the very highest level of legal scrutiny.
What does strict scrutiny mean?
The courts have different legal standards in different situations for government activity. And strict scrutiny is, as I understand it, is the highest level of scrutiny for government action.
Okay, back up. Let me rephrase my question or comment. This is when you use the term strict scrutiny in this context? Are you referring to strict scrutiny of the governmental behavior or strict scrutiny of the operation of the gun range?
Strict scrutiny of the governmental behavior.
Oh, wonderful.
And that is, as I understand it, is the same standard that is currently being used for free speech. So for the government to interfere with free speech, they have to have a proper basis, and it has to pass what they call the strict scrutiny test, which is the very highest level. The only thing higher than that is a complete prohibition on certain kinds of government action. So that actually puts things into a completely different category.
So that you can show where the city failed to abide by all of the requirements in filing in enacting the ordinance. The strict scrutiny standard application should effectively nullify the effect of the ordinance.
Well, it requires, instead of giving the court the option, as I understand it, the strict scrutiny rule says any flaw in the government action will prohibit them from proceeding forward.
So they don't have to overturn the ordinance. So they don't have to overturn the ordinance here. What they do is they restrict the city from applying the ordinance. Is that correct?
The judge actually gets, because we argued it two ways. We argued it, one, that the law as it is enacted and the procedure by which it was enacted is flawed. That's number one. Number two is we argued that we are an exceptional situation because, A, we have grandfathered rights, and B, we have grandfathered rights by appellate court order. So that our position is...
your grandfather's rights are res judicata.
Exactly. And because the county didn't make a waiver or give us an option, albeit to possibly some limited extent, and possibly we're not going to be able to expand without applying for a permit, because they didn't give us an exception to operate in the grandfathered fashion, under the strict scrutiny rule, they can't proceed. They either do it properly or they can't get any restriction at all.
Oh, this is good. It sounds like you may actually be close to at least getting the trial court portion out of the way. If you win at the trial court level, would the restrictions placed on you be lifted even though there was an appeal?
Well, remember there's two cases in two separate courts. The closure and the permit is case two. The restrictions I listed were case one. But here's the problem for them. If the judge throws out the ordinance in its entirety, or if he rules that, no, we were allowed to operate to some limited extent under our grandfathered rights, if he does either one of those, we've been closed for a calendar year unlawfully.
And
we have...
That should, even if there's two cases, if there is an adjudication on the inapplicability of the statute, then that would be collateral estoppel as to the other case.
They would argue not, because one's basically an ordinance case and one is a nuisance case. But
okay.
You're right from a practical standpoint. Because of this. They're facing the same trouble because we've got counterclaims before the same judge. He could get himself in big trouble, and he may give us a huge ruling that they don't want. So we may come to a agreed upon resolution in both cases.
That would be great. So it sounds like you're getting some leverage. Okay, hang on. Music's on, about to go to break.
I'm ready. It is.
Take this away from me.
I got this. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Please call us at 512-646-1984. We'll be right back.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Randy, would you like to continue?
Okay, Marshall. It sounds like you're making headway.
Well, I think we are, and there's a few extra facts that you might want to consider. Number one is that historically this judge, the local lawyers know his habits. He usually rules in a couple of days on cases, not more than a week, and we're 4 weeks out. That's number one. And number two, he retired in January. He has no other cases.
Oh. So maybe either he's really studying this one over or he forgot about you.
Well, I doubt he forgot about us. It's a pretty high-profile thing locally. But our lawyer's position is, because of this recent Ninth Circuit case, the county's position has become completely untenable. And they started to outline an appeals case. If he does rule against us, they want to file with the appeal within 7 days. Not notice of appeal. They want to file the appeal within 7 days. They can't, according to our lawyers, they can't win. And so our lawyers have told us to start thinking about exactly what we want in a settlement. We need to outline it and have it in hand and ready to act on it.
Let's make a deal.
And so we'll see. Of course, we want our attorney's fees. The organization has been basically bankrupted. And so we'll see. We don't want to get greedy, but we also don't want to let them off too light either.
So, yeah, they need a good hammering. Because even, if they lose, they're looking at a major lawsuit from you guys.
Well, according to one of our lawyers that has ruled, because this is basically a land use situation from our perspective, a local government abusing their power to tamper with property rights through ordinance. He's got a list of cases in this state with multi-million-dollar awards.
Oh, wonderful. This is good news, or maybe good news.
Well, we'll see. But, and I find it interesting. I having been in a lot of the court hearings myself, I've seen the judge's demeanor change from the beginning, which I would say he was certainly on the county side. He acquiesced to anything they wanted. And the last few hearings have been of a very different nature. He, at several points, sua sponte, asked the prosecutor's office questions about procedure and things that had been done and things that had not been done, without even our lawyers asking about it. And I would say his demeanor was very, very different than what it had been earlier. Of course, we got the earlier ruling. The county didn't want us to have discovery at all in a civil case. They wanted discovery banned, which is a fundamental due process right. The judge wouldn't hear any of that. He said, these people will have their discovery. So his demeanor has changed. So I'm not going to say he's on our side, but I'm much more encouraged that he's going to be even-handed than I was at the beginning of the case.
Oh, this is wonderful news, because you've been fighting this a long time. And for the most part, you've been fighting it from the underdog side. So it must feel really good to actually get to a point where you can see a light at the end of the tunnel and it's not a train coming at you.
Well, it's been kind of a lonely thing out here. Of course, the way the things were done, they did it so that they only had to fight us. They gave waivers in the ordinance so it didn't apply to shotgun ranges. And, of course, there's a favored child range that are doing as they're told, and, of course, they didn't have any problems. And we've been given a very hard time. And as I've mentioned in previous discussions with you, this is the only full-service gun range west of Puget Sound in Washington. This is not a small gun range. And so we will see, but it's looking pretty good from my perspective.
Oh, wonderful. This is good news. Nice to hear somebody hangs in there and don't give up, that eventually the worm tends to turn. So keep us up to date. Be nice on the next call to hear that you won this decision.
Sounds good. Thanks for your time, Randy.
Okay, thank you, Marshall. Okay, now we're going to Oliver in Tennessee. Hello, Oliver.
Hey, how you doing, Lon?
I'm doing good. How are you doing there with the local constabulary in Tennessee?
I don't know how to say it, but I feel good about it. I ain't worried, but I got some new things that came up. I had a situation the other day where on the 18th, they stole vehicles from my house and knocked down the house from the condemnation that they said they apparently went through. And
was the house occupied?
No, the house wasn't occupied. I suffered a fire in September, and I wasn't able to get it dealt and handle it. And they said that they went through a condemnation hearing and all that, and they condemned the house, and I needed to do this and that. I was like, well, I have private property. I kind of love my law, and I'm not going to pay you no attention. So unless, I get something in the proper form from indictments or something saying I got to get to court or whatever. But until then, whatever. So once they did that, I went and go check to see if they had anything in the record for the...
Wait a minute. Can you get the mic a little farther from your mouth? I'm getting a lot of distortion.
Okay. Can you hear me now?
Yes.
Okay. After they knocked down... As I got out of jail, I went and looked at all the records in court to see if they had anything like condemnation on my house or my property or my name or anything. They went and looked through, and she said, no, all the courts that I went through, that they have no records of anything being processed against my property or in my name.
So you're saying they didn't... Okay, I'm not familiar with the law in Tennessee concerning condemnation of property. What is the process? Is this a municipality? Are you in town?
I'm in the city.
Okay. What is the process for condemnation in the code? What does it require?
In the code. I didn't take a look at that. I have that. I can go find it when I get the chance and take a look at that. But I wasn't considering attacking that or using that. What I was considering using, I found several, as far as I'm going to use the property right, Fifth Amendment, is private property. I have no contract with them.
Okay, wait a minute. I'm not sure I understand what you're talking about here. Right. How are you getting the Fifth Amendment?
Well, what is going to be from what I saw was it had the taking clause on there, and the only way that they could condemn my property is going through a judicial. They had to have.
Okay, that's what I'm saying. What is the state procedure for property condemnation?
I got it. Okay.
You can't accuse them of not doing what they were supposed to unless you can specify what they were supposed to do.
Mm-hmm.
That should be the first place you look.
I got it.
Look in the property code on condemnation. There should be a lot on it because this is really serious and it's a big deal issue when you go when the state goes and interferes with someone else's property rights. That's a really big deal.
Right. I found a case settled in Tennessee Supreme Court 2 years ago, stating that it's called regulatory taking when they do that. And in the if they do condemn a property in the condemnation, it's stated in there. I don't have the case with me right now, but it's stated that if they do condemn it, the property owners have to be compensated for it. They have to go through a process and they have to be compensated for it. And they ruled in their favor in the same county. This is the same city, Clarksville, and Montgomery County, 2 years ago.
Oh, okay. So they've already been through this.
Yes,
and so
yeah.
Now, okay, are you familiar with the concept of collateral estoppel?
Collateral estoppel?
Collateral estoppel. Collateral estoppel is where an entity has been in court, for instance, on a condemnation. If your case is essentially the same as the prior case, and the city came in and made arguments they could do certain things, and the court ruled that they could not do those things, they can't come back into court and make that claim again. It's already been overruled. They're subject to collateral estoppel.
Collateral estoppel. Okay.
So make sure you read their cases carefully, and that case will tell you where the city has already been ruled against. So if they come back in and try to make the same argument again, then you hammer them and ask for sanctions.
Collateral estoppel. Because, that's why I said I had to call you, because I knew you were going to have a special argument, but the way that they wrote it out, their opinion, I went and read their opinion, the way that they wrote out the opinion, they made sure that they included any way or wording that they could to stop that issue from even being something to be debated about. They really clearly wrote that opinion.
That's wonderful. That's a great find, since it's in the same court. Hang on, we're about to go to break here. Hang on, we'll be right back.
This is Rule of Law Radio with Randy Kelton, Vet Pack. Please call us at 512-646-1984. Haha, Randy, I gotcha. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
You're listening to Rule of Law Radio. This is Randy Kelton, Vet Pack. We are back, and we are listening to Oliver. Oliver, please go ahead and continue.
Hold on. There we go. Got you unmuted. The clock was a little slow. Okay. So
they made it very clear, and they called it regulatory taking, and they made sure that it was just as inclusive as the Fifth Amendment protection on taking on property.
Okay.
Any regulation?
Did this court provide any prescription on determining the value of the property before they destroyed it?
Which the court, whatever process that they went through?
Yeah. Well, did the case you read provide a prescription for how to determine how much restitution you were had a right to?
If it diminished value from me having use of it or utility, then it could be up to the whole.
Wait a minute. I'm having a terrible time understanding you. Move the mic a little further away from your mouth.
A little further?
Yeah, that's better.
Okay. I haven't read that court decision as far as it was kind of long, and I was making sure I read it real slow and over, make sure I get it correct. I went and find all the words and make sure I get a correct understanding of it. So I haven't read through the whole file of it, but others that I've seen, other cases that I've seen that's similar, that if it requires utilities and a certain part of usage.
Okay, has the city made any offer of restitution?
No.
Have you requested restitution, or do you know what the procedure for that is?
It has to be in a due process court, and it has to be before they call it to action.
Wait a minute, that's too short. What is the procedure? Okay, when a municipality decides to demolish a structure or condemn a structure, is there a procedure prescribed in that process for determining the value of your property and for reimbursing you?
Yes, but I'm not 100% sure about it because I've been looking through a lot of information, but I have seen that.
Okay, very first thing you need to look at is the authority the city acted under in doing the demolition. You need to read that code. It's certainly going to be in the property code.
Okay.
You read that code first before you start doing your research. Read the code first. After you read the code, that'll tell you where to look and what kind of issues to look for.
Okay.
Okay, so call us back once you've gone through it, and let's see what options you have available to you. I can't comment on it now because I have no idea what the code is. And until you've read the code, you don't know if they followed it or didn't follow it. And you hope they didn't follow it. It gives you a better claim against them. So call us back next week and let us know where you're at.
All right.
Okay, thank you, Oliver. Okay, now we're going to Tony in Pennsylvania. Hello, Tony.
Hey, how you doing, Randy?
Doing good. What do you have for us today?
Well, first of all, can you hear me okay?
Yes, I can.
To make sure that's good. Okay. Randy, I'm going to ask you, this is a very pending matter. This just changed literally 4 hours ago. Got worse. I absolutely have to do something about this right now. I know that I talked to you about the foreclosure documents I was going to send you, but this is pertinent. This is right now. I have to do something. I mentioned this before. I looked up a little bit and tried to do a little studying about I told you about the right to evict here and the denial of due process and the denial of a remedy in court. So I simply want to get this in court. Once I get it in court, I already know what's going to happen. Getting into court is the problem. Now, what I've got here is three things. Number one, the three requirements that the city tells you to be able to file in court in the first place. You have to have a copy of the lease. If you don't have a copy, they use a verbal month-to-month term, a notice to vacate, and you have to have a copy of a rental license. This is the problem. What they've now done is I have a copy of requesting the license online, and they said that your payment is being processed. Then all of a sudden they denied it and said I had to go through all these requirements to be able to get it. So now they denied my right to court. Now, today I get a letter on my door that basically says any further payments will come to a halt until the apartment is up to code with repairs and your license to rent is restored. What that basically means is they're behind in the rent. This happens all the time. So now when they say until your license to rent is restored, that is now clear, direct damages that I am now encountering as of this moment forth because of what the city will not allow me to do in court, which I know the process in court to be once I get there. Now, I looked up, I did speak with a lawyer last week about this.
Okay, wait a minute, Tony. You didn't give us a referential index. Give us an idea. I take it from what you've said so far, this is a property that you are leasing out?
Yes.
Okay, and you have, what's the issue?
The issue is that if I didn't get into court, I would have evicted them last week before this occurred today because I saw this coming.
Okay, so you're trying to do an eviction, and what kind of license do you have to have?
They're using my rental license as hostage to deny me my due process and my right to a remedy. And when I applied for the license online, I have a document that proves that, and they said that your payment was processed, and then they denied it. So I have proof that I tried to apply for the license, and then that's the reason for not allowing me to go to court. And then this woman specifically mentions the license in the letter and says, word for word, any further payments will come to a halt until your license to rent is restored.
Wait a minute. Who is this woman?
The tenant that I want to evict.
Does the tenant have the right to cease payment based on your licensing position?
It's not current. They won't give it to me. I can't get in court to evict them.
No. That wasn't the question. Does the tenant have the? Okay. I see where you're going. In most states, a tenant can't stop payment because they have an issue with the landlord.
Well, there's a procedural error in their part. I agree with you, but the fact is, I already wanted to get rid of them, but I can't because of this issue.
You can't get it adjudicated. Is there a expedited process for the license, for securing a license?
No, they're telling me I have to meet all these crazy unfiled returns and crap, which has nothing to do with this, which takes time to do. But what I did speak with a lawyer last week, Randy, and he mentioned to me that I could file a declaratory injunctive relief, he mentioned. Now, I looked that up, and all I saw about that, a lot of it was had to do with the court and the judge. But I'm trying to get relief here, so I don't know what that has to do with the judge.
Okay, well, you're kind of being cryptic with us. What is the nature of the relief you're trying to secure? Is it eviction?
Yes.
Okay.
But in other words, once I get it filed in court, I already know what the court process is going to be. I've been doing this for almost 30 years. I need to get it into court. They're denying me the right to even get it into court.
See, what happened to the license? What was the problem with it? Did you not have one before?
They won't give it to me.
No. You've been doing this for 30 years. Was there no license requirement prior?
No. No. This what I'm referring to is a new thing that happened last year. They decided to all of a sudden decide that if you owe any money to the city for anything, it doesn't even matter if it's another property, you have to pay them. And they said that they created this little farce.
Tony, we're going to have to take a break. We will be right back. This is Rule of Law Radio. Randy Kelton, Vet Pack. Please call us 512-646-1984. We've got a few more minutes left. We'll be right back.
Oh, did you catch that yawn? Researchers have found that when someone yawns, about half the people nearby will yawn too. I'm Dr. Catherine Albrecht, and I'll be back in just a moment with the latest scientific explanation for contagious yawning.
Your search engine is watching you, recording all your searches and creating a massive database of your personal information. That's creepy. But it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
There are lots of theories about why we yawn. Some say it's caused by boredom or lack of sleep. Others blame it on the need for more oxygen. Whatever the cause, it's clear that most people react to yawns by yawning themselves. Researchers say the so-called contagious yawning is a way to synchronize with those around us biologically and socially. Scientists have found that contagious yawning is learned behavior. It starts around age 4 in children with normal development. Interestingly, children who have difficulty picking up social cues, like those with autism, aren't as susceptible to catching yawns. They yawn contagiously only half as often, and those who are severely autistic don't respond to yawns at all. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack, and we are speaking with Tony from Pennsylvania. Tony, go ahead and continue.
So anyway, Randy, you had a question for me to get clarity there?
Well, I'm trying to figure out, have you been leasing out properties for some time now?
Yes, but you know why it's tough to figure this out, Randy? Because it's really straightforward and simple, but the city tries to make it complicated. I had a license the prior year. This is a new system that they adopted, and then they denied me the license. So
do you have to refile every year?
Every year, yes. This particular license, yes. You have to refile once a year.
And did they change the procedures?
Yes.
Of what it takes to get it? Did they give adequate notice of the change in procedures?
They decided that if you owe any money to the city for anything, it doesn't even matter if that's property. It could be another property. They'll deny you licenses for everything, which is absurd. But most importantly, they're denying you your due process, and your right to a remedy in court.
And so now they make it.
Can't get rid of now.
They make it so that you can't collect your rent to be able to.
Thank you. Exactly.
Bring it up to date.
It's that absurd. What I'm saying, it's actually that absurd. Yes.
So this is so specific to Pennsylvania that
I thank you for noticing, because that's why I'm fed up about this crap, Randy. I don't even want to be here anymore. This is what they do, because it's not one thing, Randy. They do this with so many things here. It's overregulated and it's beyond ridiculous, but I don't want to rant. So I'm looking for a solution here. A lawyer mentioned about a declaratory injunctive relief. I looked up a little bit about that, and it seems to refer to a court or the judge. A lot of it,
Okay. Well, declaratory relief, you can ask for declaratory relief for most anything. Here, it seems like the licensing requirement was specifically designed to put you in the position that you're in.
Well, thank you for noticing. Exactly.
Yeah. So, okay, are you able to clear the debt you owe to the city?
Yes, but it would take time. And in the meantime, these guys are beating me out of rent. What do you do? I got bills to pay, like any landlord does. Yeah.
I really don't know what the solution for this one is. This is so specific to.
I just wanted to see if you did know, or maybe you could. They're denying. There's no question that I'm right here, because the lawyer would not have come up with this solution. There's a denial of due process, and when she wrote this today, Randy, it is directly stating that I am now, as of today, receiving damages. She said she's not paying me rent because I don't have a license, and they denied me that license, and they tell me I have to have it to file in court to get rid of them. This is damage. There's no question about it. Question is, how does your renter know you don't have a license? I'm sorry?
How does your renter know that you don't have a license?
Well, I think by the language of this letter, it looks to me, which is typical of the city, whose taxes you pay for. They tell them all these rights that they have, and but they don't explain them to them accurately, and somebody probably told them this. Because the rest of the language of the letter tells me that someone gave them this information from downtown, the people whose taxes I'm paying for, to do this to me.
Okay, what I'm looking at is tortious interference with a private contract.
Thank you.
And that would be against the city. If the city has taken some action to encourage this renter to improperly withhold payment, then that's tortious interference.
And they've done it. This is not the first time, Randy. I can tell countless times over the years. I know. Thank you for that. That's what I'm just looking for a solution here, because as of today, they're done paying me.
Okay, send a letter to the. Do you have any evidence that the city has contacted them?
That has contacted them?
Yeah, the leasehold, the lessors.
They contacted them, but I know that I let's put it this way. The way this started 2 days ago, Randy, I called this lady to verify employment because I don't believe she has the ability to pay me rent anymore. I called to verify employment. I was very struck by the strangeness of the phone call by her employer. Very strange conversation. I know she called her right away. I'm on the phone. I get these 2 anonymous phone calls in half an hour. Then a half hour later, there's a cop outside the building, and she's out to talk to him. I heard the cop say to her word for word, I did nothing wrong. So she got on her search. And then he said, you got rights, and and the cop told her, you can check here, you can call the DA's office. So he sent her the cop sent her on the search. And now we
okay. If I was a lawyer, I wouldn't tell you this.
You would not? You broke up there, Randy. What?
If I was a lawyer, I would not tell you this. But I'm not a lawyer. A lawyer will only initiate a case if he's sure he's got a shot at winning. We're not bound quite that way. What if you sued the police department for tortious interference, accusing the officer of encouraging this woman to take an illegal action against you? And they're going to swear on a stack of Bibles they didn't do it. And you're not going to care what they swear on a stack of Bibles about. You're going to insist they did it and do this through a tort letter to the city. That because the city is trying to use these coercive tactics to force you to enter into their new licensing scheme, and in order to add leverage to you, they send out their officer to encourage your renter to stop paying her rent to you. Now,
and then she follows from that point. Once she does what the officer tells her to do, she calls downtown to the municipal court, and they encourage her further. I guarantee you, I'm reading the language of this letter, and the only person who could have told her that stuff is an officer of the court.
Wonderful. So prepare a tort letter and file it with the city. Notify, giving them notice of intent to sue for tortious interference with a private contract. Now, this is a person that was a great renter that you wanted to keep forever. Do you have a lease?
Yes.
How long does the lease cover?
Well, it's funny you mention that. I structure them purposely so I don't have these problems. It's a month-to-month term, and I can go downtown if I can just get it in court. There's no question. The judge will end the term, and I'm done with these people.
That wasn't where I was going.
I understand that, but that's the term. The terms are month-to-month.
We're looking for tortious interference with the contract, and we want to show how valuable the contract is. How long has she lived in the property?
Probably a little bit over a year.
Okay, then you could claim another year's rent that you would expect to collect from this person that the city improperly cost you by its tortious interference, and ask for treble damages.
Treble damages of the year.
Yeah. Do your little research and write a lawsuit against the city for tortious interference. And then instead of a court heading, just put a business letter heading. Instead of a prayer, in place of prayer, put, make me wholly be sued as follows. and then put in what you would put in the prayer and send it to them. If it's written in the form of a lawsuit, just with a different heading on it, when the city gets it, their lawyers are going to say, well, this guy's not kidding. He really is going to sue us. And then petition for a declaratory relief allowing you to evict this non-paying person. And what's going to happen is the city's going to go to whoever the judge is and say, hey, this guy's suing us for this. How about we make a deal and you give him, allow him to evict these people, and so he don't sue us.
Exactly. That's all I want. Exactly.
In the end, it's all about the politics. Okay, is that it, Tony?
And I appreciate it. That's why I wanted to ask, and I thank you for that. So, number one, the petition for the declaratory relief.
Okay, hold on, 20 seconds. So, hang on. We're about to go to break.
I got this.
I was just explaining to him. Okay.
That's fine. We'll be right back. We'll close out the night. Randy Kelton, Vet Pack, Rule of Law Radio. We'll catch you. 512-646-1-EASY.
Okay, we are. Oops. Go ahead, Bet. My bad.
Okay, I was wondering what was going on with you. It's almost over, Randy. Come on. I know you're just so excited. This is Rule of Law Radio. We got Randy Kelton, Vet Pack. You know, we're about to close out the night. Let's go ahead and get this thing going. We'll end it with Tony. Go right ahead, Randy.
Okay, Tony, you were kind of summing up when we ran out of time.
Statutory relief and the letter to make me whole. This cases are usually heard in municipal court. So specifically, where should those two matters go? I would imagine.
This is even better. You filed a notice of tort to the city, and you filed a motion for injunctive relief with the city. And the injunctive relief is to ask the city to allow you to evict pending your license, on the grounds that you have tenants who are not paying, and they're not paying because of the city, and the city wants to collect this money. Well, you can't pay them because they interfered with your contract that helped you secure the money to pay them.
Irreparable damage, right?
Yeah, so a good chance, in order to avoid the lawsuit, they will grant you the injunction. Otherwise, they're looking at having to pay you instead of you paying them.
I agree. Now, you said protection for declaratory or injunctive relief.
Yes, the declaratory or injunctive relief act, and that goes to where you're only asking for a ruling on point of law. You're not asking for any damages. You're not claiming harm. So you claim harm in the tort letter and warn them that you're going to file a suit claiming harm. But in the declaratory judgment case, you're only asking for a declaration from the court authorizing you to evict this person who's not paying.
So are you saying the notice of tort then would be the injunctive?
No. Notice of tort is a tort letter. The court wants you to use the court as the remedy of last resort.
Okay.
Instead of the remedy of first resort. So they want you to exercise an alternative remedy. And the one alternative remedy they require is notice and opportunity. So in notice and opportunity, you give them notice that you have been harmed. You tell them how you've been harmed, and you tell them how much you've been harmed, and demand that they make you wholly be sued. So that strictly goes to the civil side. And then, or to the law, to you as the plaintiff side. No, you're still the plaintiff.
Right, but what I'm asking is,
okay, that's a suit for damages. Then you file a separate action with your municipality for declaratory relief. This doesn't get a tort letter because there's no damages. There's no harm to be cured. You're just asking for a declaration.
Municipal court now is where these matter, where the court is that this actions usually take place for eviction. Is that where these letters should go?
Yeah, no, not the municipal court. The tort letter would go to the mayor.
Okay.
Yeah, that goes to the city.
The petition for declaratory relief.
That would go to the municipal court if the municipal court actually has authority to give this ruling. would they be the ones who would hear the eviction issue? Hold on. That may not be relevant.
Where, Randy?
It is the municipality. Is it the municipality or the state that's restricting you?
The municipal court.
Okay. Is this a municipal license?
It's a yearly rental license, but that's a requirement for the municipal court to be heard in court.
Okay, that's a requirement by the municipality.
Yes.
Okay, so it's not a state license. Okay, yeah, then you would file for declaratory relief in the municipal court, asking them to waive this issue for the purpose of evicting this non-paying client.
Should I address it maybe to the president judge, perhaps?
No, you can't pick judges. Just the court itself.
Okay, like the clerk, for example.
Yeah, just to the municipal. You just name the municipal court.
Okay, and lastly, that matter about the make me whole. That part again, same thing. Municipal court.
No.
Where does that go?
Tort letter, mayor.
Yes, I got that.
Okay, that's the end of the tort letter.
Referring to the tort letter. Okay.
That's the make me whole part of the tort letter.
Okay, that was the part of the tort. I got you. Okay.
Yeah, that's what you put in place of a prayer.
I got you. Okay. So, yeah, tort letter goes to the mayor and then municipal. Okay, good stuff.
So
okay, that's good stuff. I want to, if you got 2 seconds, I wanted to tell you about the, you would ask me, I was a little flustered the other day about the conclusions of law that I got when the judge ruled against me in foreclosure.
Yes.
Okay. Well, I can speak intelligently about it. I was upset about it the other day. And basically, the judge ignored everything that we said. I established a piece of evidence in court, in trial, that the America's Wholesale Lender was not even licensed to do business until December of 2008. He didn't even address it. I made sure that my lawyer mentioned the fraud in the court, which they have a duty to investigate. Didn't even mention it. I don't even think he read the complaint.
Well,
he said that they had authority and standing, despite the fact they didn't have a license to do business, and that the 7 transfers of the mortgage still survived authority and standing to not only foreclose against me, but I didn't even have the authority and standing to challenge them. This was his ruling.
Okay, you were a little vague. You didn't have the authority to challenge them. Are you referring to the assignments?
And his conclusions of law. That I don't have the authority and standing to challenge the people that supposedly have authority and standing when they do not. In other words, it's the opposite.
The order is going to be a little more specific. Are you referring to a lack of standing to challenge an assignment of a mortgage?
Yes, he is referring to that.
Okay.
Yes, he is.
You've talked to Leslie, haven't you?
Standing to challenge the validity of the mortgage securitization or to seek a determination as to the validity of a loan assignment based on alleged noncompliance with the pooling and service agreement as the borrower is neither a party nor a third-party beneficiary of the securitization.
Okay. This is an argument we now have before the San Diego court. After the Inova decision, where the California court ruled that after foreclosure, you do have a right to challenge an assignment. And our argument is we're asking for the court to distinguish Inova and define what after foreclosure means. And we're asking the court to define after foreclosure as after the initiation of the foreclosure process. And here's the reason. When an assignment is made, it essentially doesn't have any effect on you until the holder of the assignment files a notice of default and intend to accelerate. Now the foreclosure process has begun, and it was begun by someone who received an assignment. Now you should have standing. Inova ruled that after foreclosure you have standing because of the foreclosure. And we're saying that after foreclosure should be read to read after initiation, because once that is filed in court, you're essentially defamed because you're going to get a bunch of letters from a bunch of lawyers wanting you to file bankruptcy. You have been labeled in the public record as a deadbeat. Therefore, you have a claim. If you believe that is done improper or done by someone who doesn't have standing, you've been harmed at this point. So the question we bring is, how is it different? How did my rights change from the initiation of foreclosure until the culmination of foreclosure? So are you, in your foreclosure issue, once foreclosure began, it was began by the person who held the assignment. So you should have standing to argue the assignment at that point. And there's case law all over the country supporting that.
Well, I agree with you because I brought the Gavanova case up to my lawyer, and this decision came out after that fact. I agree with you. One thing that concerns me all the time with my lawyer, he seems to want to minimize these other decisions throughout the nation as to say, well, they're not state-specific, and I don't necessarily agree with him.
Well, what was the nature of the assignments? Okay, you had a original lender who wasn't licensed to do business in the state. There's a case out of Florida where MERS did an assignment for American Wholesale Lenders. I'm sorry. There's a case out of Florida where American Wholesale Lenders was the original lender. Are you familiar with that case?
Yes.
Okay. That one.
He's telling me the cases in Florida are not that important here. I said, what? I don't understand that part.
It's directly on point. He should use that as a what's the term? Just informative. Okay, I'm sorry, we are out of time. Am I right? Where are we at? Yeah, we're out of time.
Yeah, anyway, you get a little more feel.
Okay.
Hey, thank you so much for your time and your help.
Okay, we got to go. Randy Kelton, Vet Stevens, Vet Pack. I screwed up the outro.